Hello and welcome to the Minimum Competence episode for Tuesday, September 23rd, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, Trump's TikTok divestment deal, U.S. law firms pulling back from China, a new lawsuit against Zillow, and why states should tax digital products by function. Let's remember, politics is the art of looking for trouble, finding it everywhere, diagnosing it incorrectly, and applying the wrong remedies. And read today's legal news. On this day in legal history, September 23rd, 1957, 9 African-American students, later known as the Little Rock Nine, were barred from entering Central High School in Little Rock, Arkansas, despite a federal court order mandating desegregation. This confrontation became a pivotal moment in the civil rights movement and a key test of federal authority to enforce the Supreme Court's 1954 decision in Brown v. Board of Education, which declared racial segregation in public schools unconstitutional. Arkansas Governor Orval Faubus, no relation, had deployed the National Guard earlier that month to prevent the students from entering the school, citing concerns about public safety. On September 23rd, the students attempted to enter the school through a side door. Although they briefly succeeded, a growing and increasingly violent white mob outside forced officials to remove the students for their safety. The local police were unable to contain the mob, highlighting the state's failure to comply with federal law. The national spotlight turned sharply toward Little Rock, prompting President Dwight D. Eisenhower to intervene. The next day, September 24th, he federalized the Arkansas National Guard and sent in the 101st Airborne Division to enforce the students' right to attend the school, which they did under armed guard on September 25th. This event marked the first time since Reconstruction that federal troops were used in the South to enforce civil rights. It underscored the constitutional principle of federal supremacy and the power of the federal government to uphold civil rights against state resistance. President Trump is set to sign an executive order this week confirming that a proposed deal to restructure TikTok's U.S. operations will satisfy the 2024 law requiring divestment from its Chinese parent, ByteDance. Under the arrangement, ByteDance would retain less than 20% ownership, while American investors, including Trump-aligned figures like Lachlan Murdoch, Larry Ellison, and Michael Dell, would take control of the U.S. business. The restructuring would install a U.S.-based board with national security credentials aiming to quell longstanding fears that TikTok user data could be accessed by the Chinese government. We, of course, want to make sure only the American government can spy on us. The executive order also pauses enforcement of the divestment mandate for 120 days, buying time to finalize the deal and secure regulatory sign-offs. While the U.S. government will not take a board seat or a, quote, golden share, it remains unclear whether the final agreement will involve any direct financial benefit to the federal government itself. Still, Trump's fingerprints are all over the transaction, from its nationalistic framing to the prominent role of political allies in the investor pool. He's even credited TikTok with helping him connect to young voters, a not-so-subtle nod to the platform's political utility heading into 2026. This deal marks rare progress in U.S.-China economic talks, which have been largely stalled amid broader trade tensions. But it also reflects a larger trend: Trump's willingness to insert the federal government directly into private sector negotiations, whether by greenlighting chip exports to China or taking equity in major tech firms. Critics argue such moves undermine free market principles and risk long-term damage to U.S. competitiveness. Supporters, however, see it as a strategic economic defense. In short, Trump's TikTok solution is part national security play, part corporate reshuffling, and part political theater. Whether it holds up legally or operationally may matter less than the narrative, the U.S. regaining control of a culturally dominant platform while sidelining Beijing. And speaking of Beijing, K&L Gates is closing its Beijing office, becoming the latest U.S. big law firm to retreat from China amid ongoing geopolitical tensions and a sluggish legal market. The Pittsburgh-based firm will consolidate its Beijing operations into its Shanghai office following a leadership review of global strategy and real estate. The move comes under new global managing partner Stacey Ackerman, who took the helm in July. Though K&L Gates will maintain a presence in Shanghai, Hong Kong, and elsewhere in Asia, its exit from Beijing reflects a broader trend. Over the past 2 years, major U.S. firms like Wilson Sonsini, Clearly Gottlieb, and Winston & Strawn have also shuttered offices in China due to declining deal flow and increased scrutiny of foreign businesses. While some firms continue to operate in Chinese cities, the heyday of aggressive U.S. legal expansion into China, peaking about a decade ago, appears to be over. The firm's departure underscores the mounting challenges of navigating China's legal environment in an era of strategic decoupling. Zillow is facing a new proposed class action lawsuit accusing it of deceiving homebuyers by steering them toward its own network of affiliated agents rather than the actual listing agents. Filed in Seattle, the suit claims Zillow's platform misleads users into contacting agents who financially benefit the company, sometimes giving Zillow as much as 40% of their commissions, without disclosing this arrangement to buyers or sellers. The plaintiff, an Oregon resident, argues that these tactics violate both Washington state consumer protection laws and federal real estate laws by inflating commissions and limiting consumer choice. The suit alleges Zillow's practices result in higher home prices and a lack of transparency about who truly represents the buyer's interests. The legal team behind the suit characterizes Zillow's business model as one that exploits consumers' need for housing to boost profits. Zillow has pushed back, calling the lawsuit a misrepresentation of its operations and defending its model as pro-consumer. This case adds to a growing list of legal challenges for the real estate giant, which is already battling other lawsuits over competition and marketing practices, including one from brokerage Compass and another from Homes.com owner CoStar. And my column for Bloomberg this week, I argue that as states try to modernize sales tax rules for the digital economy, they should stop framing digital offerings as either goods or services and start taxing them based on function. The Multi-State Tax Commission, or MTC, is circulating a proposal to define, quote, automated digital products as those sold with minimal human intervention. While well-intentioned, this definition is fuzzy and risks creating more confusion than clarity. For example, how do we categorize a chatbot that occasionally escalates to a live agent or AI tools that require ongoing human training? These gray areas aren't new. States have spent years litigating whether software is tangible, intangible, or a service, and this could be a repeat of that same cycle. Instead of defining digital products by how much human effort goes into delivering them, we should define them by what they do. A Netflix subscription is entertainment, QuickBooks is a productivity tool, and therapy on Zoom is healthcare. Consumers already experience digital services this way, and tax codes should align accordingly. Function-based categories would mirror existing tax practices, like how business deductions or ticket sales are handled, and would be far easier to scale to emerging technologies. It's true that a functional model still faces edge cases. ChatGPT, for instance, could be research, productivity, or entertainment depending on use. But these are better problems to have than trying to parse human involvement in the delivery pipeline. If states want to tax digital products sensibly, they need a system that reflects how people actually use these tools, not how they're coded or deployed. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading and all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, politicians and diapers must be changed often and for the same reason.